Hello, everybody. We're back to podcast. This is due to popular demand, and with us today is Joshua Dayan, who's joining us, who is part of our firm. He heads the injury part of the firm. And Nicholas. Everybody knows Nicholas Dayan, and my name is Albert Dayan, as everybody knows. And go ahead, Josh.
And we're happy to be back. And just a disclaimer: when you hire one of us, you hire all three of us.
That's right.
This is the team over
I'm
here.
not sure if it's a disclaimer. It's a promotion. It's a promotional type of thing.
Yeah.
Thank you for the introduction. So just to dive right in, Nick, I heard you made the New York Law Journal. Tell us about that.
So it's an interesting case I beat. I was dealing with it for 2 years. It was a gun case. It was a C-violent felony. The individual I was representing was one of 4 defendants, and he was looking at 3.5 to 15 years if convicted of this crime. Now, it was a very interesting case with a lot of pressure from the DA's office on how they were going to try and convict at least one of the individuals in this car.
How is this? I'm sorry. How is this different pressure than other gun cases?
So every gun case comes with its own, pressure for the DA's office because they take guns very, very seriously. This one specifically, the DA's office didn't want to let fall through the cracks. These are 2 of the defendants in this case were well-known individuals. They had some notoriety on social media. It was a very publicized car stop. There was a lot of eyewitnesses who saw this car stop, and it was tied to a shooting. Well, that was the DA's position, that they found this gun because they were investigating a shooting, and they didn't want to let this case go, like any other case. But I suppressed this gun, and now the DA's office has no case. They're going to ultimately have no choice but to drop it.
I mean, making a law journal, I've been practicing for a long time. I made the New York Times, New York Post, but to make a law journal, it must have been something very, very complex and interesting about this particular case.
So the legal issues that we were able to bring to light was very, very unique. Doesn't come across quite often, right? So you have the typical car stops and the typical questions: did the officer have probable cause to search the vehicle and find the contraband? These are all typical questions every defendant is faced with. But this specific case had such unique legal issues. And I could tell you the story of what happened, right?
Well, please.
Okay. So you have 4 individuals, 4 friends who want to go out it's late one evening. They want to go out to a club, and they all decide to get in one of their friends' Mercedes-Benz S-Class. This is a very expensive car. It's a 6-figure vehicle. It's all tinted out, black rims, and they're driving. They're driving in Queens. And as they're driving, simultaneously, there is a radio run on the NYPD database that says a person who just ran into a car, into a BMW SUV, just shot a gun at somebody, got into his car, and rammed into a NYPD police car that tried to stop it and is evading police. That is the description that was given on the radio run. Black SUV BMW, no license plate, has front end damage, and the driver is a shooter who just shot at somebody.
But your car was a Mercedes.
So our car was a Mercedes S-Class sedan. Now, the sedan is driving through side roads and on a highway at a reasonable speed. And now there's officers looking for this quote-unquote SUV.
So how do they notify all the officers? Like a radio run? They say they describe a vehicle, or
so radio runs is as a way of communication for officers. So let's just, for example purposes, say the 114th precinct gives a radio run over on their walkie-talkies. Hey, this is what just happened. Neighboring police precincts, for example, like the 113th would also get that radio run because it's in the same vicinity. So maybe that suspect or that suspect's vehicle crossed the border. So that's what happened in this case. A neighboring NYPD police department got those radio runs, and now there's undercover officers in an unmarked vehicle who get this radio run, who are in the vicinity. And as they get this radio run, they see this black S-Class sedan, not an SUV. But obviously, it's a very intense situation. So officers are moving quickly, right? There's a gun that was just shot. An officer was just assaulted with a car in his car. We got to figure out what's going on. We got to find it. So they're trying to act quickly. And, respect to them too, to the officers. But anyways, they lock eyes on this sedan and they start following it. And the testimony from the officers that the sedan was not driving erratically and that it gets onto a highway and that this unmarked police car with 3 officers inside of it is following it. And as it's following it on the Van Wyck, it's making, its own radio runs. We're following this car. This is the license plate. And that's his testimony. It's very vague. The officer is obviously trying to protect the record.
So basically, if that officer believed that was the same vehicle that was involved in the shooting, why would he take so long to follow him? So you basically, on their testimony, to be quite frank, you must have cracked his credibility.
Very, very badly. I broke him apart.
And further, why not give more details about the car rather than giving a vague testimony?
So this is the hurdle you're always going against. You would expect that when you're cross-examining any witness, that they're going to tell you exactly how it was. But that's never the case. You are now going against the prosecutor and the officer at the same time. Why? The officer and the prosecutor are in communication.
Prior to the testimony.
Prior to the testimony.
So they and that's natural, right? And any prosecutor and witness who's going to deny it, that's bullshit, right? They always twig it. Always twig it.
I agree.
So that's why, like, when you crack them once in a while, that's that's not easy to do. And that's why this case to me is such an interesting case, right? How they try to pull over a completely unrelated car using a pretext of another incident that happened a while ago. And go ahead, you go on. It's just an interesting, fascinating.
It is, because officers, they're not lawyers. So as much training as they have in the police academy, they're not educated to the level an experienced prosecutor or experienced defense attorney is. But they get to spend time with an experienced prosecutor who is watching the body cam footage, who is listening to the radio runs, who is looking at the DD5s. These are the detectives' police reports in the case. And they are explaining to the officer the goal that needs to be established in this hearing or in this trial. So obviously the prosecutor is going to, tell the officer, look, be careful with these types of questions. For example, if they're going to ask you, was he driving erratically? Try to throw it in there that he was.
Well, I'm not sure if they really go out and really tell them what to say. I don't think they do that, but they do it in a way that is so clever. They ask the question where the implication of the answer is so obvious in that question. Yes. And they feed off each other. Obviously, they feel like this is, they doing the right thing, even if it's, it's tweaking it a little bit. And for you to stand there and cross-examination, pick it off, and obviously the judge is always assessing the credibility of the police officer. And
well, one of the things that's interesting, you say that one piece of the testimony that the officer was trying to throw in to this hearing was that when the car, this Mercedes sedan, got onto this highway, it sped up as if it was trying to evade the police.
See, the question is, right, Josh? The question is, if you believe that vehicle was involved in a shooting, why do you wait for it to speed up? So the police officer obviously is speaking and shooting from both ends of his mouth at this time.
Yes.
I mean, I wasn't there at the hearing. I could only imagine what you did with all that.
So I could only suspect, just from instinct and experience and listening to his testimony, that the reason he tried to testify on direct that this vehicle tried to evade him was because in case that he couldn't get him on the probable cause for the description of the BMW as a mistake of an officer, that it was an allowable mistake under the circumstances, he would now get the probable cause because this car tried to evade him and it had tints, and that in and of itself is probable cause to pull it
So let
over.
me ask you a question. You think that the police officer on his own realized that?
Not at all. I know that was from the right coaching. And you know what? That's their job, but it's also our job to catch on to it. And that's why we're
their
here.
job, but you know what it is? You can't really hide behind that theory of, doing the wrong thing for the right reason.
Oh, I agree. If it was up to me, that would never happen. There would be no reason for a witness in a case, especially an NYPD officer, to have to meet with the district attorney, watch his body cam footage, go through the discovery, go through the questions that are going to be asked on direct examination. And direct examination is when in criminal cases is when the prosecutor is asking the question to the officer. And I know you both know this. I'm just saying it for our viewers what direct is.
But actually, if I can just chime in on that, on this issue of the officer and the prosecutor being really on the same team, right? They're on the team of law enforcement. So the prosecutors are prepping their witness, the officer.
We're not.
Well, you deal with that all the time.
Exactly.
So Josh, he deals with personal injury, and also he deals with wrongful arrest cases where individuals who are innocent get arrested and in some cases have their teeth broken or all their bones broken because of mistakes of officers.
And that's exactly why I'm bringing this up, is because I recently deposed an NYPD officer who, in his own negligence and recklessness, caused a catastrophic accident with my client, right? He ran a red light. He admitted to running that red light. He ended up in a busy intersection where my client ended up colliding with him, right?
So when he ran that red light, I'm going to ask you about this case because it's a fascinating case. Was it an accident, or based upon the evidence that you have thus far, what were they looking for this individual? Was it a mistaken identity? What caused this accident? Why did this cop go through this red light?
Very good question. So the officers, they were responding to a shot spotter alert. And what that is for our viewers is technology around the city that can pinpoint shots that were heard. And it doesn't necessarily need to be gunshots. It could be maybe an
exhaust from a car.
Exactly.
Yeah.
So sometimes you're saying these shot spotters pick up what they believe to be a gunshot, but it's not. It could be a construction site that something falls and slams on the floor.
Does it give you the vicinity?
It gives you the vicinity.
Right.
But what I'm talking about in this case, when I deposed that officer, right, I asked him questions about a previous affidavit he submitted, and that's a sworn document he submitted in that lawsuit. And when I asked him when he prepared this document, his response to me was, "I didn't prepare this document." I said, "What do you mean? You swore to its truth. You signed it under a notary who prepared it." He said, I didn't write it. The lawyer for the city wrote it for me."
Interesting.
And you see, that just goes back to the whole issue of prepping.
And did you ask him if he read it before he signed it?
I asked him. He said, "I read it. It's all true."
So
but
basically,
he was shocked by my question.
It goes back to the police officer listening to basically abiding by the coaching of the legal representative, whether it's the ADA, an assistant district attorney, or a corporation counsel attorney that represents them in civil actions. But tell us more about this incident. Like, how did it come about that this was a collision?
So it's a very, very interesting case. So my client, he's a law-abiding guy. He was just driving his moped bike, and it so happened that a shot spotter alert caught something that sounded like a gun. The police were alerted to it, to the shot spotter alert on their radios, and they wanted to pull this guy over because he was riding a moped, and they thought, you know what, let's give him a try.
So it's like a roulette. Like, you know what, this guy, he's black, he's riding a moped.
100%.
Let's see if he has a gun.
100%. And you know what? In the deposition, I asked the officer, "Did you see him with a gun?" "No." Did you see him point the gun? No. Did you see any indication that this man had bullets, any gun, anything?
I read the transcript.
Exactly.
And you asked, was there any,
A bulge sticking out, things of that nature.
or did anyone give a description of the individual who might have shot, or are you just going off of a shot spotter? But go on.
They went off of a hunch, a complete hunch that they had a shot spotter and they see this guy in a moped and they thought, you know what, let's give him a shot. So the way they pull him over in this case was so reckless, because what happened was the officer who ultimately pulled right in front of his moped was hiding at an intersection behind a red traffic light with his lights and sirens off at night, right? So picture that.
Mhm.
It's dark outside.
So they anticipated his arrival at that destination at a certain time, and they just pulled up in front of him?
Exactly. They pulled up in front of him. We caught all of this on video from a nearby surveillance camera. And the officer runs that red light, no sirens on, stops right in front of him 2 seconds before a huge collision, an explosion. My client, he broke almost every bone in his body. He ended up in the hospital for 113 days.
I'm sorry to interrupt, but what's interesting is that if my memory serves me correct, and I'm sure it does, the officer's initial, explanation as to why this accident happened was that they were just driving through an intersection and didn't realize that this guy moped was coming. But through your investigation of the evidence and the video footage in this case, it showed that in fact the officer had his lights and sirens off. The light he was driving against was red. The right of way was for the moped, and that it's that the officer drove into this intersection and stopped in order to stop this moped.
So just on that point, right? So what we did uncover, right, through the testimony of that officer was that he ran the red light and stopped in the intersection, but his explanation was that he wasn't trying to stop my client, right? It was that he was trying to stop to give my client a chance to avoid a crash. But you know what the best explanation for that is? If you want to give someone the best chance to avoid a crash, don't run a red light, don't stop in the middle of running traffic, and don't stop right in front of him.
Yeah, but let me play the devil's advocate, okay, guys? Just slow down a little bit. All right. If I'm driving through an intersection and I see a car stopped at an intersection, I would either stop or go around. And why wouldn't the moped do that?
Because the officer waited. Go ahead.
Let me talk about that. So it's a good question.
I know it's a good question.
It's a good question.
It's a very easy answer.
It's a very easy answer, but it's a good question.
So one thing good before you answer. One good thing that I'm glad that our audience is experiencing, that we actually talk about every case amongst ourselves, whether it's a criminal case, whether it's a personal injury case, whether it's a wrongful arrest case. As you see, we all know about each other's cases.
That's right.
Well, go ahead.
Yeah.
You hire all three of us. That's the way it works.
That's the firm. So on that, to answer your question, right? That officer, he ran a red light. When you're driving and moving traffic, you're not expecting suddenly some kind of object to appear in front of you. And if you are, it should be at least more than 2 seconds before you have to make that decision, right? So that officer, he pulled into that intersection and abruptly stopped, giving my client about 2 seconds to respond at night when that officer did not have his lights and sirens on.
Are you suggesting that the only reason the police officer did that was because he had anticipated your client arriving at that intersection at a certain speed, at a certain time, and to prevent that wall between the client and that intersection so the client would not be able to drive by?
The officer definitely knew my client was going to be there because he admitted in his testimony, right?
Well, how fast was your client going? Let's start with that. Was he flying?
He was going the speed limit.
No, he was going.
He was going the speed limit.
He testified that he was driving above the speed limit.
Well, that's
right?
the officer's testimony.
No, I'm saying that my client testified that he was driving above the speed limit, right?
Did the officer know that? Did the officer know that? Was it timed in such a way that in order to cause that collision?
You could only suspect. We can't go into the mind of the officer, but we could only We could only draw inferences from the evidence we have in front of us.
That's my question.
Yeah.
So he was not driving slow. It's a fact.
He, meaning the...
My client, he was not driving slow.
Did the police officer know that? Because
He knew that
How
because
did
he
he
was
know that?
listening to the radio alert,
Right.
which, and he admitted to listening to that radio alert, where the officer who was putting out the alert stated, "We are about to hit this intersection."
Oh, so you didn't tell
But
me
that's
that.
what I was trying to get to.
Right, you didn't say
Yeah.
that. So that makes a world of difference. So there's somebody following your client
Yes.
who's basically radioing, we're about to pass this intersection.
exactly.
Okay, now that's different,
Yes.
of course.
Yeah. So that whole case is a very interesting case. Now, of course, the world of criminal defense and injury sometimes intersect, right, with officers who are negligent or reckless and cause injuries. So it's an interesting intersect over
So,
there.
that's what I think it's a very interesting concept of what helps defense attorneys in their hearings and in their trials. And the more hearings and the more trials I do, and just for our viewers, we litigate. The three of us are litigators. We don't take pleas so easy. We don't. He doesn't settle cases so easy. Any case we take, we are prepared to fight it. But just to get back to my point, it's always the officers who try to be lawyers on the witness stand is what gives us the ammunition to tear them apart.
Yeah, that's the downfall of a police officer who tries to become a lawyer on that witness stand. But this case, just to go back on this case, that's a valid point, Nick. But just to go back on this point, I recall the man that you represent on this moped. He was also arrested at that scene, right? Even though he got terribly burned, terribly hurt. What was he arrested for?
So he was arrested for.
Well, whatever. I don't know if can we even mention that since Nick dismissed the case?
Yeah, the case is done, so we shouldn't. He was arrested. We were able to resolve all criminal charges for him.
So I think we dismissed all the criminal charges.
All felony charges were dismissed. All misdemeanor charges were dismissed.
Oh, that's all
Correct?
criminal. There is no other criminal.
So that's not correct.
Okay, go ahead.
That's not correct. So now he was charged with a lot of different charges, right? So
Possession
he was
of
charged with
drugs.
He was charged with possession of drugs. He was charged with reckless driving, right? He was charged with not wearing a helmet, so certain like VTL infractions. But interestingly, right, he was not charged with evading a police officer because that officer behind him was not trying to pull him over. That's just a story they came up with after to try to justify the whole situation. But at the time, before they knew that there was a lawsuit, they did not charge him with evading a police officer because it did not fit their narrative yet.
Got it.
Okay.
All right.
So, anyways, I'm gonna get back to.
You're here.
How officers.
We forgot why we were here.
No, we're just here to talk. So, back to my point about officers trying to become lawyers, right? On the witness stand. So you have this officer out of nowhere throws a curveball for the first time throughout the pendency of this case after we received all the evidence that this car was trying to evade him, right? Once it got on a highway, it sped up and then it stopped because of traffic. And, through my cross-examination, I was able to show that this cop, to say it as lawyerly as possible, was full of shit. That this car got on a highway, it was an open highway, and he drove up to the speed limit. He wasn't weaving in and out of lanes. The officer's lights and sirens were not on. The officer was not directly behind him. It's an unmarked vehicle, meaning there's no NYPD decals or lights sticking out on the vehicle. And now, this Mercedes hits traffic, and this officer gets behind it. And I said, "Officer, at this point, are your lights and sirens on?" "No." Is this car weaving in and out of traffic? No. When it got off the highway, did it stop at the red lights? Did it stop at the stop signs before it reached its destination of this club? Yes. So ultimately, he knew that his attempt to establish probable cause that this vehicle was trying to evade the officer was an epic fail. And I caught on to it. Most attorneys would probably miss that point because that was not the main focus of this hearing. But anyways, they get in front of the club. They pull over this vehicle, lights and sirens on. They make everyone step out of the vehicle. Simultaneously, you have both precincts, officers from both precincts drive up to the scene. There's approximately 15 to 20 officers now on the scene. They pull these individuals out of the car, pat them down, and patting down an individual during a car stop is actually not against the law. And a lot of people think that once you're pulled over by an officer, you're not required to come out of the car. But it's well-established law that has been litigated that if you are pulled over by an officer, for officer safety, he is allowed to ask you to step out of the vehicle and pat you down. He's not allowed to conduct a thorough search of you, but he's allowed to pat you down.
Yeah, for safety reasons. But what if he pats you down? And obviously, we know the answer. But if he pats you down and doesn't feel a bulge or a gun, but he feels other contraband, let's say he feels a bag of marijuana, right? Is there a plain touch exception as opposed to plain view, right? Except just for our viewers, plain view, if a police officer looks inside the car and sees a contraband, that's in plain view. Or if they execute a search warrant for something and they walk into an apartment and something is just laying there, that's in plain view, right? So they're not really searching for it. But is there such a thing as it's called a plain touch exception? Means if they're looking for a gun, but because for their own safety and they feel some other contraband, the answer is no. Obviously, right? There is no plain touch exception. He can't say I was patting him down for a gun because my safety was in question in the middle of the highway, but I felt a pouch of marijuana. The law does not allow him to go inside the pants or the jacket and retrieve that marijuana, that contraband. That's called plain touch. For our viewers, that's called plain touch exception.
Yeah.
But yeah, go ahead.
So anyways, now they pull all these individuals out, and it's a very intense type of situation because now officers are very heated. They think they just found the shooters. Some officers came to the scene, didn't know what the hell was going on. You could tell they're just amped up like a football team. Oh, we got the guys. Let's get him. So they're treating all these 4 kids who are fully cooperative with the officers. Come out with their hands up. What's going on, officers? We're just here. We pulled up in front of the club. Is this car stolen? No, the car's not stolen. It's our car. It's registered. Everything is okay. They're getting pat down. And as this is happening, no one is searching the car yet. There's a sergeant on the scene. And then there's the officer who put in this radio run for a black SUV. They're all communicating and they decide that, look, this is not the car that we were looking for. This is not even the right license plate. This is a completely different car. So at this point, all the officers agreed that this is not the car. We pulled over the wrong car. We got 4 kids out of this car, patted them down.
Kids, they're not kids.
They're 25 years old, almost.
For you, maybe they're kids.
They're scared. You could tell I'm calling them kids because you should have seen the look on their face in this body cam. Like they had 20 cops.
They had a gun inside the car.
Look, so this is the thing. One, this Mercedes S-Class was owned by the driver of this vehicle. But it was one of his cars because he would rent out these vehicles. So this was his business. But on this specific day, this car wasn't rented. He used it for himself.
Where was the gun?
And this gun was found in the back seat, in the center console, the middle compartment that goes down in a deep pocket.
Wasn't your client seated in the back seat?
He was seated there, but this is a rental car.
Was his brother also seated in the back seat?
Yeah, 2 of them. Right. So what? That's not their car.
Oh, so it just so happens that the rental car just has the...
Look,
again,
I know, but we don't know who rents these cars. And this is the issue we fight all the time because we don't know who rents these cars. We don't know the people who were driving this car before, who might have left a gun over there. You have to look at these cases not from your perspective. Oh, if I had a gun, I wouldn't leave it just anywhere. But you're dealing with a different caliber of people.
No, I appreciate the fact that you don't crack under my cynical questions and you keep that zeal and that belief in the innocence of individuals.
Because now you have one gun, 4 kids in the car. It's obviously not everyone sharing one gun. So is it possible that this gun could have, it's a possibility, belong to one of these individuals? It's possible. This gun had no DNA on it.
But if any of those individuals are in the car, I'm sorry, if all of these individuals are in the car with knowledge that the gun is in the car, are they all under the law constructively possessing the firearm?
If there is knowledge, if you know the gun is there, then yes, under the constructive theory, you are guilty. But now the prosecutor has to prove that you knew the gun was there. The gun had no DNA. Well, it had DNA, but it was just not suitable for comparison because there were so many
contributors.
Yeah, it was 5 or more contributors. They couldn't test this gun for DNA.
Now, one day we should talk about the testimony that the prosecutors offer when there's too many contributors, how they try to walk around it and say, well, it's, it could be one of the defendants' DNA on it, but it's just too many contributors. We don't test it. They say we don't test it. It doesn't mean that the defendant's DNA is not on it. They say we just don't test it if it's more than 3 or 5 contributors.
Can the prosecutor bring that in at trial?
Yeah,
so they do.
That sounds unfair.
I've had many trials where especially I had a trial in Brooklyn where the gun was not suitable for DNA, and they brought an expert who said there is DNA on this gun. We just don't test it. It's our policy. So
you know what? That sounds unconstitutional to me and unfair to the defendant's rights.
Yeah, we make that argument in summation that lack of evidence is reasonable doubt. There's a jury charge where the judge says to the jurors, well, the prosecutor is not obligated to bring in all the evidence. They're not obligated to bring DNA. You can really, reach a decision based upon what's in front of you. And we as defense counsels argue that, look, lack of evidence, not enough evidence is reasonable doubt. But then you have so many things that kick in, the jurors look at the DA's office. Oh, if they didn't believe the defendant was guilty, why would they prosecute him? That means it's very difficult to overcome this whole concept of.
Well, that's the issues we fight all the time, and it becomes frustrating because, on its face, the world, or let's say New York City, doesn't know what happens in criminal cases. They see little bits and pieces in the news, but I would say that that almost everyone I represent is a good person. Even the guy who got caught with a gun, and I don't want to make this too political, but even the 21-year-old who got caught with a gun is not a bad guy. He's not the guy walking around because he wants to commit a robbery. He's the guy who just is 21 years old, made a mistake, bought a gun, didn't know what he's buying, didn't know the severity of it, and now he's looking at jail time.
He didn't know. He knew he was buying a gun.
He knew he was buying a gun, but he didn't buy it to hurt anyone. Some of these people grow up.
So you say it gave him some sort of recognition,
notoriety, and also some of these guys don't grow up in good neighborhoods. Some of these people grow up in neighborhoods where they see people getting hurt and robbed and shot, and they have moms and sisters, and they say, "Look, I don't feel comfortable walking down this street at 12 o'clock at night because I finish work late at night, walking down the street. I'm scared someone's going to try to hurt me. I'm going to walk around with a gun because people have guns in this neighborhood." It's not an unreasonable way to think. Or what about one of our clients? He's a jeweler. He's been robbed at gunpoint 5 times. He runs a legitimate business. I know this guy. Everyone he went to high school with who didn't know what to do after high school, they were just lost. He took them in. They work for him. They have girlfriends now. They pay their own rent. They pay their taxes. Just a good guy. And I've seen videos of him being robbed at gunpoint. So he bought a gun. He gets caught with a gun. He shouldn't go to jail. Okay, yes, he could apply for a license. But in between the time he needs to apply for a license in New York until the time he gets it is at least a year. During that year, you're driving around with $100,000 in merchandise that you took on consignment, you're responsible for. Insurance companies no longer want to insure you because you're high risk, you keep getting robbed. You need to put yourself in situations where you could sell this jewelry, so you need to be flashy. And yet, he gets caught with a gun? No, we're going to put him in jail.
So are you suggesting that obviously there is a difference between someone who purchases a gun to rob a jeweler, and there's a difference between a jeweler who purchases a gun to protect themselves against an armed robbery, right? So how can the DA's office, right, differentiate between the two? First of all, do they, or do they, or do they, or do they? I just want to finish my question. Or do they sort of like use a template, right, to prosecute these individuals? Unfortunately, maybe because they don't have the staffing, the DA's office, maybe they don't have the time to look at each and every case, which is really a constitutional tragedy, right? Yeah. Because not all the defendants that we represent are similarly situated individuals. Each one has a history with which they come into the criminal courthouse with. Each one of them has a background, family dynamics. And that, what you're asking for is basically for the DA's office to devote a tremendous resource to sit there and differentiate between each and every one of these defendants and fashion a recommendation of what the sentence should be, because the judge's hands are locked. When you're charged with a possession of a firearm as a C violent felony, even if you're the judge's nephew, the judge's got to give you 3.5 minimum.
Yep. So look, I'm not going to get into details about different counties specifically, but we have the benefit of practicing in all 5 boroughs in New York, including Nassau County, Suffolk County. So we get a taste of every different prosecutor's office on how they deal with, specific cases or any case. Is it a template type of situation? We don't care if you're a priest or a nun. You got caught with this, you're going to jail. My view on this situation is that there are some DA's offices, and I'm not going to say which one is which, that really take the time to say, you know what? Tell us about this guy. We want to know him before we offer him jail. You know what? Jail might not be necessary for this individual. So and then there's some counties that are very frustrating that tell you, sorry, it's our policy. And you know what? Their policy comes to bite them because they put us defense attorneys in positions where we say, okay, that's your policy. Now we're going to fight you on every case. You want to fight? Let's fight. And I'm not going to say which county is which, but there needs to be some balance. And you need to look at an individual before you send him to jail. Even if your case is rock solid against him, you need to look at them as humans. I've heard this too often where, what's the big deal? It's 2 years. I've heard DAs tell me it's just 2 years.
Just because they visited Rikers Island for 2 hours.
They haven't even been there.
No, some of them, let's assume they have, 2 years. 2 years, that's in a man's life, a woman's life, it doesn't matter who. That's a profound amount of time. Especially, think about it, you got to go to Rikers Island, right? You spend there a month. It's garbage can. You eat out of the same place where you basically, it's like a garbage can.
The conditions are horrible. Yeah.
Then from there, they send you to downstate for about a month, which is hellhole because that's where they decide where to send you upstate. Then they send you upstate. And again, someplace 6 hours away that you don't see your family for 2 years. I think that a year, if you want to crush someone just for possessing a firearm, right, and nothing else, and obviously the man's never used it, never has had a history of violence. You want to crush a guy, give him a year. Yeah, you want to crush a guy,
crushing him,
right?
That's crushing him. But yeah, and they talk about numbers like it's nothing. It's 2 years. Are you kidding me? 2 years? It took me 3 years to go to law school. I became a lawyer after 3 years in law school. 2 years is a long time to sit in a cell. Given programming. First of all, jail in and of itself costs us taxpayers a tremendous amount of money. We're not rehabilitating people by sending them into a jungle. Look, there are cases where, I don't think, unfortunately, the system is no longer concerned about rehabilitation. It's all about general deterrence. Let's crush this guy so the next guy is going to think twice about not possessing a firearm. That's called general deterrence. The specific deterrence, let's punish him enough so he doesn't do it again. 99% of people we represent, after the first conviction, after some sort of a prison time, probationary period, some sort of regulatory supervision, is not going back to a criminal justice, is not getting involved back in the criminal justice system. Well, on that point, this case that with this gun I suppressed with 4 people in the car, no DNA on this gun. Before the decision came from the judge and before it was suppressed, one of the conversations I had with this prosecutor was, I said, look, let's say this case doesn't get suppressed. I said, let's say we do the suppression hearing and the judge decides against us. And obviously now we have to go to trial. I said, are you going to stand before a jury in front of all 4 of these kids, 4 of these men, let's call them men, and try to
Young men.
and prosecute all 4 of them for one gun that you have no DNA for, and take a chance that all 4 could get convicted and go to jail. Meanwhile, it could be one person's gun. Obviously, we don't know whose. None of them are talking. No one's taking the blame for it.
That's an excellent argument. That's an amazing argument in front of the jury if you would have had to go that far, right? It's completely plausible, possible that maybe one person didn't know. Let's assume one person didn't know, right? So let's assume the other 3 person did know. Is it really worth convicting one innocent person to put away 3 other ones who knew?
No.
Exactly.
No.
But that's what I mean by template. It's like a revolving door. It's like nobody wants to take a look at these people individually, right, and talk to them. And I really gotta give all of us, our firm. I think the fact that we are able to put together these arguments with mitigation packages, and also grateful to Joshua that really helps us with that, because sometimes we fall with such a busy trial schedule. But that is an important position.
Well, I think that's what differentiates us, is because we really care about our clients. They don't sit, I know when they sit across from us, I never have that thought of, I'm the lawyer, I have the suit and tie, and judge this individual. I actually really try to get in his mind, like, what happened in this person's life. And I try to take that sympathy and really put it in the DA's mind. But this is where another issue comes up. You're talking to the prosecutor sometimes, and they might really understand you. Like, Mr. Dayan, everything you're saying to me makes sense.
But they can't sell it to the supervisor.
But the supervisor's saying no, and this is my job.
No, it's because they don't. When they go to the supervisor, unfortunately, they're not you. They don't have the same beliefs. They don't have the same vision. They can't sell it, and that's why I got to give the supervisors credit in all the boroughs.
Yeah,
they do see us. They do see us.
They do. They put in that work. They
do
have
see us.
So many cases to deal with. They do. They deal with a lot. But we make our way into their office whenever necessary.
No matter what. Exactly. No matter what. And I tell you, that is really the difference between a good lawyer and a great lawyer, is never give up. Don't ever give up. You got to speak to one ADA, you speak to 10 of them. You got to speak to 2 supervisors, you speak to all of them. And that's really because we talk about nephews. Every one of our clients should be represented as if they are our family. And because, and this is, I take pride in teaching my sons that we are a family, and everyone, and this, I know it sounds like an advertisement, but it's not. Everyone that comes into our office, if you don't look at them as family, then you have no business in this business, right? You have no business in this business. It's like, you got to give that man everything.
Well, just even the way I see Josh handle his civil cases. Every case he takes from the start to finish is prepped for trial. And why is that important? You see so many personal injury firms, right? So many wrongful arrest firms that take these cases with the intention of settling it within 3 months. It's quick money. We want to take this case, settle it.
You can't blame those firms, because none of those firms have trial lawyers. They have no trial experience, right? So, and don't you think that do insurance companies know who they're dealing with as a firm? Tell us about that.
So insurance companies, they definitely know, right? So they look at they have a database. They look at how easy it was to get someone to settle. On a case that's worth $100,000, you'll be surprised. A lot of lawyers, they'll settle it for $10,000 just to get the quick money, because they don't want to put in that extra couple months to fight, Well,
you have cases that are going on for 2 years now.
Exactly. I have cases that are going on for 2 years, but again, I treat my clients like family, our clients like family, and they feel it. And that's the difference between the great firms and the firms that just want to make a quick buck, and they'll sell out their own client just to get a quick check. That's not what we do here.
That's not the right way to practice. If you took a case, and that's one thing Bob
it's not their fault. They don't know. Don't you understand? Not every lawyer, that's what I'm trying to say. Not every lawyer can walk into a courtroom and cross-examine a police officer or create diagrams and charts and know the procedure about how to introduce expert witness testimony. That's not for everyone. And the insurance companies, they know they're so sophisticated. Think about it. Ultimately, every insurance company is about money, right? Don't you think they invested millions of dollars to know which firms, what they do, when they settle? Do they settle like during the first discovery stage, or do they settle right after depositions, or do they settle on the eve of trial, or do these guys get actually put on a case?
So it really depends on the lawyer, that's handling the case. Because if you have a lawyer who, comes across as he just wants to make a deal, he just wants to get that check, he wants to make a deal no matter what, the insurance company is going to sense that weakness. They're going to sense it.
And you know what? That is the same thing that happens in criminal cases. The DA's office knows who's a fighter and who's not. They know. And ultimately, that's one thing that I'm very grateful for, that one of the first things I learned in this office, obviously from my dad, was that you take a case, you better be ready and willing to fight it. Don't take a retainer from someone and have the mindset of how we're going to resolve this. You took it, be ready to fight it. And that's what every client wants. He wants someone who's going to stand up for him and speak for him, because he can't.
And
How
the
many-
DA's,
Go ahead.
I'm sorry, the
Sorry.
DA's office, they know that you guys would go to trial.
And interesting.
We
How many
do.
times? How
Exactly.
many times do we have clients who basically come to us? They can't articulate the facts, but when you sit there and you listen to them, right, and you're able to speak for them, the relief they get, the sense of relief. That's like, yes, this is exactly what happened, is what I hear very often. But they try to articulate it. Most of the time, they just aren't able. Look, not everyone's got the ability, right? But go ahead, tell me about this settlement process. How does it work?
So, it's really about making sure that you as the lawyer control the way your firm looks in the insurance company's mind, right? On the other side of that phone call, there is someone who is analyzing your every word, your every step. You don't want to give any sign of weakness. You want to make them know that you're going to take this case to the end, to trial in front of a jury, and that you're going to win.
So let me ask you something. Does it matter if you have, for example, 300 lawyers or less lawyers in a plaintiff's firm?
I think what matters is the confidence that's projected and the amount of pressure that's placed on that insurance company, right? So regardless of how many lawyers you have, as long as your firm is treating every case like it's the most important case in their firm, they're going to squeeze that insurance company till the end.
Well, obviously, if I'm tell me if you disagree, Nick. If you're, let's say, an adjuster or a defense lawyer for the insurance company, and you hear a lawyer, plaintiff's lawyer, and as articulate, for example, as I hate to say this, not because you're my son, but as articulate as Josh, as knowledgeable as Josh.
This is Ivy League.
Yeah. Yeah, and this is when you would say, okay, this guy speaks well, he's articulate, he knows the case, he knows the law. He's not a template lawyer.
They see that just from the legal proceedings that are filed, that this is not a template firm. Because a lot of personal injury firms file template documents that it looks like a fifth grader wrote it. I see the cases that are put together. I read the pleadings. I read the summary judgment motions. Can't even compare. They know, the insurance company knows, we're dealing with a litigator. He's prepping this case for the end goal. He wants to be in front of a jury.
Yeah, and it's like I said, they'll analyze you from the complaint all the way down through everything you do. They're going to see if you're a fighter or if you're just going to sell out your client first.
What's this case we have about the search warrant that they went into a wrong apartment? You want to?
yeah,
That's an interesting case.
Very, very, very
That's a
interesting
good
case.
one.
Sir, that's not your case.
I know, but that's a good. I love.
get it.
That's a good case.
Very interesting case. So,
We're gonna send this podcast to the insurance company.
Just briefly, because
I'll just briefly, right? So, there is a stigma in this country, right? Where, like you said, right, Pop, that when someone's in front of a jury, people may subconsciously think that, he must be here for a reason, right? Look at the DA's office, look at the officers. They put so much work against this guy. There must be something. But a testament to that being false is how many people get falsely arrested in New York City alone. The city of New York has spent hundreds of millions of dollars just in the last year settling police misconduct lawsuits. So I have 2 clients right now.
We should use that in jury voir dire. Can you accept the proposition, right? Not only that innocent men or women get arrested, prosecuted, go to jail, but New York City settles hundreds of millions of dollars worth of cases for wrongful arrests. Because jurors don't see that. Josh is right.
True. They only see
he's guilty.
They see one article in New York Times about some random migrant who came in here and stabbed someone, and they think, oh, everyone's in the criminal justice system's associated with this guy. You know,
that's called moral panic.
Moral panic.
Yeah,
wow, look at what's happening in New York.
Exactly, but unfortunately, a lot of innocent people end up being arrested and prosecuted.
We keep cutting them off. Go ahead.
So let me tell you guys. So I have these two young women, right? They were living in an apartment complex, and they happened to live down the hall in the same building as suspects that the police had who they believed had a gun. So the police believed these two people in apartment, let's say B, had a gun. But my clients, innocent woman, lived in apartment A. So the police, they obtained a search warrant for that apartment B, explaining that this is their basis for probable cause. They have a confidential informant that is telling them that the gun is in that apartment, right? And the officers, for what seems just to be a hunch, obtained a search warrant for apartment A, for my client's apartment.
But did they get one for B or just A?
And B.
Oh, so they got for
B
both.
and A. They went, raided both apartments. They found the gun in apartment B, in those suspects' apartment. But in my client's apartment, right, two girls lived there.
Two sisters.
They found nothing.
And good girls.
They found absolutely nothing. And on body cam, you can hear the officers saying, there has to be something here. There has to be something here.
Tearing apart their whole house.
Destroyed their home. And the officer on body cam said, the sergeant, we'll just charge them with money laundering.
Because they had some money in the house. Not a lot.
Not a lot of money they had in the house.
What's not allowed?
A couple thousand. That's not a lot.
That couple of $1,000 in their home.
Any person could get birthday money, bar mitzvah money, you name it, right? And they said on body cam, there has to be here something.
So they charged them with a crime.
Yes, they're the only Spanish people on the block. They must know each other. That's what was said on the body cam. And they arrested.
They said those words?
They said those words.
Wow. I'd love to try this case in the Bronx.
Exactly. And that's,
anywhere. This is
Yeah, you're right. Anywhere.
That's a case I filed in federal court.
And actually, we've realized, the three of us, that filing wrongful arrest cases in federal court is actually a benefit because it moves quicker. There's no delay tactics by the city where they're stalling a case for 2-3 years. You're dealing with a federal judge who does not mess around. You're not going to tell a federal judge, I can't file papers today.
The judge in federal court is telling you better have your papers filed by this day, otherwise your case is dismissed. Otherwise, I'm putting in a default judgment against you. There's no messing around.
Is that the majority of, you feel that's the majority of your work now is you file your cases in federal court to move it along faster?
I think I have a good balance between federal court and state court. Certain jurisdictions in state court, they are known that they're very plaintiff friendly, right? They're known for that you can get them.
So it's strategic.
It's a nice balance. It's all about the strategy. So that's it goes back to what we were talking about, is going back to a firm, choosing a firm that will pay attention to even the nuances of your case.
Well,
treat everyone like
strategy and experience is very important. And I'm gonna talk about one case. And we all represented this one young individual. I'm not gonna say his name. No criminal record. Grew up in Queens, moved to Long Island with his family. Comes back to Queens to hang out with some friends, right? And they pull up to a restaurant. He's in the front seat waiting for them to come out. They were going to get takeout and go to someone's house and eat it and hang out. As this is happening, he sees someone across the street who he used to know, like from the neighborhood, from Queens. This guy's running. He recognizes our client, says hi to him from far as he's running to his car, gets into the back seat of our client's car from one side, from the driver's side, and runs out after 3-4 seconds on the other side.
Yeah.
Now, this client doesn't know what just happened. Like that was the most weird encounter that could have happened to me. This guy ran into the back seat and ran out through the other side.
That's a incredible fact pattern. Let me guess. There's a gun that's found in the back seat.
So now
it's not a guess. Obviously, I know the case.
Yeah. So a gun is. But hold on. So now he sees cops pull up behind him. What's going on? Maybe I'm double parked. Let me move my car. He drives up, moves his car. Now officers turn on their lights and sirens and pull him over, come up to the car, looking crazed for him. And he really doesn't know what's going on. He's a good boy. All our clients are good.
All your clients are good boys.
All our clients are good boys. But anyways, there's a gun literally in plain view in the back seat. They arrest my client. Now he's the only one in the car. He's telling me, Nick, this case has been going on for some time now. My other attorney has been waiving speedy trial time to try to work out a disposition, but it's really not my gun. I don't know what's going on. And now I don't really remember the other lawyer's name.
It doesn't matter.
It doesn't matter. And I wouldn't say it anyways, but ultimately he came and hired us because he says, look, this lawyer is coming to me and saying, I need to cooperate with the district attorney's office in order for them to give me some sort of deal or maybe some probation in this case. He's like, Nick, it's not my gun. I'm telling you, I think the guy who ran in my car threw it. But he's like, I don't want to my life is so far from this life. I don't want to start cooperating with the district.
How old was he?
He was no more than 21 years old. He's young, such a good boy. Like
I love it. All his boys are good boys.
I grow a liking to all my clients.
All his boys are good boys and not guilty.
I grow a liking to these clients. They're not. I can't even call them clients anymore. They call me at 10 o'clock at night. We'll text. We'll talk on the phone. It's not a 9 to 5 type of situation. So he's like, Nick, I don't want to start working for the DA's office. I'm not a cooperator. Like I could get killed. Like this is an unfortunate situation, and it really sounds like a movie, like a comic. Like someone ran in your car, dropped a gun, and left. Mind you, I get involved in the case. And the judge is like, look, Mr. Dayan, I know you just got involved in the case, but this is a very old case, and he's not indicted yet. His other lawyer's been waiving time. What are we doing? I said, Judge, just to get straight to the point, I don't need a lot of time to get acquainted with this case. I know the facts. The DA could send me the discovery. We're withdrawing our waivers. I want my client to testify in the grand jury about what happened. Now everyone's like shocked. Like, what do you mean? This is the move you want to do? This was my chess move because I said you want to force this guy to become a cooperator for you, and when he's telling you he's innocent, he offered to give his DNA on the gun, but you can't test it because there's so much DNA on the gun. He wants to come in and he wants to fight this case in the grand jury. If they decide it's not guilty, that there's no true bill, case is tossed out. So now I caught the DA's office by surprise. They get rid of the prosecutor who was on the case. They put a more experienced prosecutor. And ultimately, he testifies in the grand jury. He comes in, he tells them the story, and the grand jury believed him because there was testimony from a cop that said, I saw someone run from his car, run into his car, and run out. So he was not contradicting himself. This is what happened.
So you dismissed the case in the
grand jury. And he was so thankful. And he said, Nick, I for almost a year that I was dealing with this case, I didn't know what to do. I was scared that I was going to go to jail. My mom was coming to court with me. I have a sister who's in the medical field. Like we're a well-to-do family. I was lost. And my lawyer was telling me that I need to cooperate, that's my only option, and maybe I'll get probation. But this is where experience comes in. You need to know procedure. You need to know how to fight cases. You need to know every loophole. Not a loophole. I don't want to call it a loophole, but you need to know every tool you have in your toolbox.
Every procedural angle. The procedure is very important.
Yes.
Obviously, procedure is very important. Procedure and law, those are two different things. That's why we have two different publications. One is criminal procedural law, and the other one is just penal law.
Yeah, exactly.
They're two different things.
And when it comes, obviously, you never want, it's almost like an unspoken rule. If you had to learn it in law school, it's not written down. But in a criminal case, you do not want a defendant who you're representing to ever make any statements, ever, right? That's the unspoken rule. But the way I look at cases, right, and when it comes to a defendant making a statement or testifying in the grand jury, is that if your defense will never change, meaning this is what happened, and even if the grand jury doesn't believe you and you have to take this case to trial, your words will never be contradicted.
So in other words, when you tell, I think in the words of Mark Twain, if you tell the truth, you don't have to remember it.